My Lords, before the short adjournment, we were considering the different tests and what actually was on the table and what the position is. Just want to clarify and make sure we have this all clearly in our minds. The starting point is that we had understood from my learned friend's submissions is they were asking for this court to adopt the any hardware position from the EPA, whilst retaining, without any real amendment, the Pozzoli approach of the UK. We explained in our written case, and for your Lordship's reference, it's our pages 104, 105, picking up from His Honour Judge Burse, as he then was in Re Halliburton, why, to use his term, that will not do. And you effectively end up giving no effect to the exclusion at all. A learned friend in his oral submissions has moved on to a modification of the Pozzoli test, which I'll come back at in a moment. But it has never been part of this appeal, the position which was considered in Aerotel of the UK courts adopting any hardware plus convict.
I didn't understand it to be part of the appellant's case that we get rid of Pozzoli or do anything about Pozzoli. Yeah. What I understood him to be saying is that we should adopt what the EPO, I think, call the intermediate step, and we apply that analysis. And provided you do that, you can go on at the stage of inventiveness and use any test you like, if it's Pozzoli or something else. But there's no reason that I've understood yet why we can't adopt what they call the intermediate step without following it through into problem solution, which may be a problem for another day for this court. But I don't see that we're being asked to adopt that on this appeal.
So I'm grateful for that guidance, my Lord. Just for your completeness of your Lordship's note, my learned friend does deal with the problem solution issue at paragraph 135 of his written case at page 65. And he says in the first sentence of 135, the English jurisprudence has always been a little cautious with some aspects of the problem solution approach. And then he provides a footnote at 65 referring to both Actavis and Novartis, a long section of some 16 paragraphs, and Rambaxi and Warner-Lambert, another 22 paragraphs where the courts have variously explained what the problem is with the problem solution approach. So your Lordships have those authorities or extracts of those authorities in the bundle, so that's for completeness. So we then move on to my learned friend's modified Pozzoli approach. And the first thing I pick up is what's on his additional piece of paper. And what he tells us is when considering a mixed invention, first dispute, are we a mixed invention, the assessment and inventive step must take into account all those features which contribute to the technical character of the invention, so include some things, and exclude all those features which don't contribute to the technical character of the invention, so remove some other things.
Well, isn't this what they call the intermediate step in the European jurisprudence?
It's a paraphrase of do what the EPO does, tied to the construe the claim test at step 2 in Pozzoli. But it's mere guidance. Include that which should be included, exclude things that shouldn't be excluded, but look at the invention as a whole. And the problem is that that is mere guidance.
Mere what?
Mere guidance. And what one ends up necessarily with is a claim which has been construed, at least excluding certain features. Now that isn't what we presently do for taking that claim for example, for infringement. Because you've got to include those features for the infringement case. It means that on every revocation case, we're going to end up with an argument about how you actually apply this test. As I say, the EPO doesn't have to worry about infringement. Also, the way they do it in Convic is they don't exclude those features which contribute to the that don't contribute to the technical character of the invention. They move them. They move them to the problem portion of the assessment so that they are still looking at the invention as a whole.
But that's because of their particular technique.
Well, it is.
It's a way of excluding them.
It is a way of excluding them. That's absolutely fine. But there is no such structure in Pozzoli. So where do we move them to? You can't just do this. You've got to find somewhere to move them to so you can do the last bit of the sentence. The invention as a whole. Well, I've just excluded features and I've got nowhere to move them to, so I've got to find somewhere to put them back in. And the result is, what my learned friends are really just saying is, do any hardware, plus you're going to need to change Pozzoli to try and give some effects to the intermediate step. But there's no actual process that works, that's been taken through for this court to sanction. Yes, I can see that with a worked example. I can see how it's a sensible test. I can see how it gets to the same result as any hardware plus convec. And I can see how you can leave out section 2A, for an example, and still end up with knowing what the claim should be for where the claim construction needs to be used elsewhere in UK patent law.
But isn't that always the case? I mean, if these features are in the claim, when it comes to the UK, they're going to have to be considered for infringement purposes anyway.
They are, but as my Lord appreciates that when one, at the moment, the test we use for construe the claim in the second step of Pozzoli is the same claim construction under the same principles which we use for infringement, as we're talking about, and in other areas. The difficulty is with modifying the test so that suddenly you have less than the claim, with parts of the features excluded and parts of them included in some part of the case, but not in other parts of the case. One's giving rise to a dispute about the way in which they were cut out, the way in which the inventive concept of the claim was different, whether one was looking at excluded subject, a case that rises excluded matter, whether a different technique is used for cases that don't involve excluded subject matter, and what test we use when we come, for example, to infringement. At the moment, all the pieces of the UK system join together, they add up and they work. And because there hasn't been a proposition of modifying Pozzoli, that wasn't really my learned friend's case, which is why it's had to hand it up. Because there wasn't a proposition of Pozzoli, there's very little opportunity to work out what this is. But what this isn't is a step 1, step 2, step 3, something that we can sit down and the Comptroller or the courts or advocates can sit and say, I know how to apply this. This is just an obvious desiderata as to what test I need to construct. But it tells me nothing about how to do it. And that's where it differs from the EPO existing test, which we can see what the test is, we can see how to apply it, and we can analyse to see whether it's got differences to Aerotel. And simply sending the entire patent profession away with the instructions of, well, whatever you do, don't do Aerotel, try and do something that the EPO does. You don't need to do convec, so don't worry yourselves trying to do convec. Stay within Pozzoli, but see if you can implement the intermediate step. And the intermediate step is modified, it is convec, it's the modified problem solution. They pulled it out, even though in practice they don't deal with it as 1, 2, 3. That was just for analysis. They deal with the intermediate step and the inventive step part with convec. And my client is the Comptroller.
I haven't understood at the moment why this causes problems with infringement. What is the question I have to ask on infringement that would make this difficult, and which doesn't arise at the moment when you have to apply the current Aerotel exclusion approach?
So the difference is this, that let's look at inventive step. To keep it simple, take the exclusions out. Normally when you've got a piece of prior art, which is the prior art, and you've got a document that explains what the alleged infringement are, documentary disclosure of both. I construe the claim once, and then I compare it with the prior art document, and I tick off what features are there, and if necessary, what's obvious. And I look at the description of the infringement, and I go through, and each and every feature of the claim needs to be there, and I tick it through. I've got one claim construction, and it ensures that there's no messing about by the patentee. It ensures there's no saying my claim is very narrow so as to avoid the prior art, but saying it's very broad so that I catch infringement. It's often been described as the golden thread of the way we proceed in this jurisdiction. One construction to rule all purposes. The moment you come along and say, for the purpose of inventive step, at least in an excluded subject matter case, you need a different approach to construction which excludes all those features which do not contribute to the technical character of the invention. That test cannot be used for the purpose of infringement, because if those features are in the claim, they have to be present for infringement. Certainly according to our existing law. It doesn't matter that they're non-technical, they've got to be there.
It would operate in that sense as a limitation, I suppose, effectively put in by the patentee, which would limit the scope of the claim more than its technical contribution might otherwise suggest was necessary.
But isn't it limited anyway by the approach that's gone through in Aerotel?
No, because in Aerotel you're doing a separate test of actual contribution as a first stage test, mainly doing it on the alleged contribution, just for sorting out the excluded subject matter. When you come over to inventive step, you do Pozzoli. And you do it on the whole of the claim, not worrying about the exclusions. And combining the two together leaves you with two different constructions. And which do you use? And it just means that in each and every case, we are going to be sat there. Paragraph 1 of our skeletons is, we are told we have got to do paragraph 2A of Pozzoli. Whatever the examiner did, he did it wrong. And we'll be arguing about how he went about it, how it wouldn't be what you'd get if you did it under the convict approach, which is what it's supposed to be trying to do. And every prosecution case that would be rejected would be on appeal to the Patents Court and beyond, trying to implement this test. Because we don't know what it means. We don't know how to go about it. It's mere guidance. Try and do what the EPO does, but we're not telling you how to do it.
Well, I mean, do you have a concrete submission as to what we should do if we think that following the guidance from wherever you like to find it, Aerotel, Lord Newburgh, everywhere else, that there is a decision of the enlarged board which does say you start with any hardware and work on from there, that we think we've got to grapple with that and start with any hardware. And my reading of your written case is that leads you to applying convict.
You potentially start, if you start saying, this is the problem with not finding a divergence, if I may. If you find a divergence substantively, and by that I mean to a different result, between any hardware plus config, the EPO approach, and Pozzoli in the UK, then you know what the problem is. You know what the failure of the Aerotel scheme might be. And then the correct way to go about it is to make changes, subtle changes to Aerotel to close out that problem. The moment you start saying that there isn't a reason to do it, but we're going to do it anyway, what one's really saying is the UK can forget setting up its current jurisprudence, as it has done for decades, on the operation of the patent system in the UK, taking into account that our patent office works differently to the EPO's patent office, that our courts have to deal with infringement, which isn't an issue for the European Patent Office, then you end up ceding the jurisdiction of this court to a EPO organisation which has never been supreme to the UK. And
I have a problem at the moment reconciling, maybe I just haven't followed through your submissions, but on the one hand you're saying there's no substantive difference between the two approaches, and on the other that the roof will fall in if we adopt a different method of getting to the same result.
Well, the difference is that because the construe the claim, what does the patent's monopoly cover, which is like absolutely fundamental to the heart of patent law. Because that is at the centre of this, the way it's developing under Convic, is you suddenly end up with having to jettison decades of learning in the UK. All of the training of the hearing officers, of which there's some 400 odd, examiners in the Intellectual Property Office, and making them have to pick up the European process, which we've never used.
Well, it would be great. I mean, if Aristotle got wonderful endorsements from the UK courts, that might be one thing, but you haven't addressed, for example, Lord Justice Lewison's comments on it in HTO, is it called, who was absolutely scathing about the Aristotle approach. It doesn't seem as though everybody here thinks it's wonderful and that, you know, they do funny things on the continent which we should not follow.
There are different people who have said different things about the UK test, both within the country and without. Lord Justice Lewison's approach in a number of different areas of patent law is whenever the lawyers start setting out a three-part test or something of that, he likes to point out that it's helpful to go really back to the statute. But that hasn't stopped both lawyers and the lawyers in the court setting out multi-part tests from time to time, because in practice one does find them helpful compared with just, well, you've just got to go to the statutory words and the court's never going to say anything beyond those. And back in its day, the EPO there was a bit of a spat because there isn't a supremacy between the EPO and the UK. These are judges of coordinate jurisdiction, both sitting down and working out what they think should happen. And one judge comes up with one way of doing it, and in another jurisdiction, perhaps there's a little intemperate, statements about, well, I wouldn't have done it that way, and I don't think what you've done makes any sense. And backwards and forwards it goes. And over the years, some of our judges have been more inclined to get into those sort of debates than others. But nevertheless, both tests, the EPO approach and the UK approach, have been fixed for 20 years or so now. And this is the first case that's reached this court, not because people have been knocking on the door, because there's a problem. Because
well, it hasn't been available really until the enlarged board decision in 2021.
Which was
and it was bound to come to a head after that, given what had been said before.
Well, at some point.
Well, indeed, Lord Justice Jacob said so in terms.
Yeah, so at some point. But then the question comes. The question isn't pre-dictated by what's been said before when we didn't know what the enlarged board was going to address. And when the issue wasn't firmly before the court, to say, okay, we know the enlarged board does it like this, but should we adopt it in the UK or should we not? Now I say, first good reason for not doing it is there's no apparent difference. Second reason is it really does require us to be sure what we're doing to other areas of patent law.
When you say there's no apparent difference, your submission, as I understand it more accurately, is that the UK is presently applying the statutory test.
Yes.
Both are endeavouring to apply the statutory test.
Exactly. And there hasn't been shown. In fact, actually, my Lord Kitchener very helpfully puts that, because it really isn't. The EPO isn't supreme, and it really isn't whether we're right or wrong against the Supreme. The starting point is what we're doing in the UK on Aerotel. Does it or does it not implement the statute? And we can't see it on a basis where it doesn't.
Of course, but where we are directed by a lot of authority, is that where the EPO has made up its mind about what the convention, the relevant bit of it, means, rather than merely how best procedurally to go about implementing it, then we ought to follow it unless we're sure they're heading for the rocks. And I keep coming back to the problem that I think the EPO are saying the reason why Aerotel is not compliant, not just incompatible, they say, with the convention, is that the convention, in clear, express and unvarnished terms, applies the exceptions to the question whether there's an invention at all, not to the subsequent questions. Whereas Aerotel jumps straight to the subsequent questions once it's construed the patent, or construed the claims.
But there's a number of issues with that. Firstly, we do look at the whole of the claim, because we take into account the alleged contribution before even getting the exceptions out of their box on Aerotel. The other issue that's always a complaint said in respect of the, in Duns, for example, is what are we doing getting the prior art out? But the solution to that in the EPO is mere window dressing to have an any hardware stage that doesn't do anything. They actually do the exclusions entirely in the context of inventive step with the closest prior art out. So the major criticisms that they make of the UK simply don't hold water. These are judges who...
I can't conceive of a single claim that couldn't be have some reference, either expressly or implicitly, to hardware.
Well, quite.
And whether related to a computer or a computer program or anything.
That's right. If one takes any hardware on its own, then the exclusions have absolutely no meaning. You don't even have to consider, am I talking about a business method, or am I talking about the computer program exception, or am I talking about aesthetics creation? Forget that. Stick a mug in it, or stick a computer in it, or stick a bit of the internet in it, and you pass the test without even looking at the subparts of the test. So all of the work in the EPO gets done under Conveg. And all of that is mixed up with inventive step, which is the very complaint that they made years ago in Duns about the UK approach. What are you doing thinking about the state of the art? We have got no guidance in EPC 52 about having the state of art in mind when doing the exclusions. So it's window dressing.
Well, why is that window dressing? Because the way they do it, there's a test for prior art, and their complaint is that when it's done at the exclusion stage under Aerotel, there's a concept of prior art used in Aerotel which has no counterpart in the legislation.
Why it's window dressing is if you pass the any hardware test, they say you pass Article 52.2. Right? And then they sneak the exclusions list from Article 52.2 back in on inventive step, because as my Lord Stevens makes absolutely clear, what they count as passing Article 52.2 doesn't do anything. So it's window dressing to say, oh, we deal with Article 52.2 without looking at the prior art at all. Well, in part they do. But the real work happens when they get to inventive step and they're looking at the closest prior art. It is window dressing that there is a difference in approach or a procedural failure or a substantive failure with Aerotel. It's as simple as that.
Well, how does that answer their criticism that when we're dealing with prior art under Aerotel, it's an undefined concept of prior art, whereas on their approach, it's part of inventiveness, which is a well-established concept?
But they do it twice. They do one type of prior art, state of the art for novelty, and a different one for inventive step. They tend to mention the inventive step one. But we only, my learned co-junior doesn't like me calling it triage, but it's more gatekeeper or triage when we do the actual contribution. The office is able to say, not from looking at individual documents, but is able to say, look, these things seem absolutely commonplace to me. I don't think they're what I should be focusing my attention on. There's a safeguard there is a safeguard of the alleged contribution. If the patentee is really stamping his or her foot and saying, no, I really want you to keep that, then it can be kept. So it gets done at a very high level, and then the assertions of actually whether something is part of the state of the art, insofar as it's being left over, because in effect there wasn't agreement, those are dealt with under the statutory requirements for the state of the art, either under novelty or under an inventive step. So it's a convenient way of focusing on what really matters.
I haven't detected much in your submissions about the question of whether or not something can contribute insofar as it is combined with a novel feature. So, as I understand it, it's accepted broadly that something which is old and in the claim can contribute to the technical effect, can produce a technical contribution if it is combined with another feature so as to produce a new effect.
Yes.
Is that right?
Yes, that's conventional patent.
Yes. Now, how does that work under the UK approach?
So it works in exactly the same way as it does actually in the EPO. We're focusing on the UK work. What we're looking for is the actual contribution. In the words of Mr. Burris QC, as he then was, that are adopted in Aerotel. What is it that the patentee has really added to human knowledge, or words to that effect? And that actually really allows you to pick up those interactions. Right? Yes, it's an old computer, yes, it's an old database, but what the real contribution here is whatever it might be in the given case. It absolutely enables you to focus on the true contribution with the guidance from the applicant, the alleged contribution. It's trying to get to the nub of it and not getting distracted by claims that sometimes can go on for over a page or more, trying to find out what is it you've really done. And that allows you to look at old things without getting worried about them being excluded. It allows you to take into account interactions, and it works. And the EPO tries to do the same thing by not removing at all anything, but moving bits over to the problem side. But they have the same difficulty, he says hypothetically, which is where there's an interaction, I've got to make sure that the way in which I move over to the problem doesn't just move over everything that's old, or everything that's excluded. It's a computer, off it goes, it's a database, off it goes. I've got to look to see whether there's that interaction. It's always going to involve skill and judgment. And there's no automatic answer given to you by doing convic. And it requires the skill and experience of the patent examiners and the established law on how we do it under Aerotel to focus on what matters. But specifically on Aerotel, the alleged contribution is an absolute safeguard. So, if your law, yes. So I'm very aware of time, so I must move on. There's one other, or two other points I just wanted to briefly draw out, and they're interrelated. And this is the practical effect of Aerotel in the examination process in the United Kingdom. I'll take this quite quickly, picking it up from my written case at, it's page 108, and it's the section 17.5 sub B point. A lot of applications come into the UK IPO. One of the things that the Aerotel test allows you to do, which anything like Convic doesn't, is to assess for excluded subject matter without moving on to the prior art search. And for my lords who may not be familiar with it, the prior art search, or often called the search, is where the patent examiner has to check all of the record databases that are available to him or her to find potential prior art. It's a complex and expensive and laborious process, not least because all contending documents that come up need to be read and carefully considered to find out what they disclose. Now, in the UK, a discretion has been given to the patent examiners by section 17(5)(b) of the Patents Act not to perform a search where it wouldn't serve a useful purpose. And under Aerotel, when the patent examiner receives claims which look like they have got a severe exclusive subject matter problem, Aerotel can be passed quickly before the search and sent back to the applicant. There's then two things that happen. One of two things happen. Either the applicant says, oh, you're absolutely right, I can't prosecute this patent in the UK, and they go. Or, perhaps more normally, they revise their claims, trying to add technical features to them in order to pass the exclusions. Now, why you say, does this happen? A very significant reason as to why it happens is a lot of patent applications actually originate from jurisdictions that don't have equivalents of the exclusions, notably in the papers, the United States and Japan. So people just cross-file here. Patent examiner looks at them and says, well, this might be all right in the United States, but it doesn't meet the requirements of the EPC. Can go through Aerotel, can return the application to the applicant, who can then revise it. And if they do revise it, a search can then be done, if it passes at that stage, on the technical subject matter of the search. If the office has to move to search before being able to deal with those claims, it will result in a significant number of searches which at the moment wouldn't be being performed. And what's more, when
who pays for them?
Who pays for them? They're part of the fees paid for on the application. So the application is paid and the office doesn't always have to do the search, which obviously contributes to the overall budget of the office. In some cases take a lot of work, some cases take a little work. So suddenly one has to have the searches done, then the claims are amended because they were unallowable, technical features are added to claim, and the search has to be done again. So certainly as a matter of practical application, we've got a statutory power in the office, which isn't tied specifically to the excluded subject matter, but it's significantly used in the UK Intellectual Property Office, in the exclusion cases, to reduce the burden on the office for those cases where a search is never going to be required. And if we move to any form of test which includes consideration of the prior art, and that's convict or modified solely, because they come into the same approach because you've moved on to the inventive step stage, then it's going to significantly increase the burden for the office and is going to mean that the statutory provision which Parliament has seen fit to give the Comptroller will very, very rarely be able to be exercised.
And it will take longer, presumably.
And it will take longer, exactly, my Lord. Or we'll have to have more patent examiners, which will put costs up. And one of the real advantages of the UKIPO at the moment is that the costs in the UK are, I heard over lunch, tenfold different on the patent applications compared with the EPO. And one of the ways we achieve that is by limiting our search effort. And obviously I only give you that, my Lords, anecdotally, and I can't tie it directly to the search. The Comptroller sees it as a very significant part of the process. Now, if we're doing something wrong and we're ending up with different results, then that's a different case. But if we're not doing anything wrong and we're implementing the UPC in accordance with the UPC, then procedural interventions do need to be taken into account rather than simply follow the EPO for the sake of it. My Lords, unless there is anything further I can assist you with, I'll make way for Dr. Edward Stewart.
Just before you sit down, may I ask, you were going to consider the adjournment, whether an example came to mind about how how the EPO approach might be applied.
Yes. So I did look at this over the journal, and I'm grateful to you, my Lord, for reminding me. It's quite complicated because even the simple examples in the guideline go over a couple of pages or more, and trying to paraphrase it orally is going to cause a problem.
Would it be easier if we just looked at the
What I can
guideline?
direct your Lordship to
Yes.
is the EPO Guidelines for Examination, Part G, Chapter 7, and Section 5.4.2, which provides 5 worked examples of applying convic.
Do we have that in our papers?
No, you don't, my Lord.
But you can provide it to us.
I can provide it, absolutely.
Thank you.
My Lords, unless I can be of any greater assistance.
My Lords, it falls to me to address you on issues 3 and 4. And as the appellant explains on page 33 of the bundle at paragraph 11, these issues only arise if the court rejects the appellant's first and second issues. And over the page at paragraph 15, the appellant contends that each of these on its own is sufficient for the appeal to succeed. So the scenario here is that the appellant has failed to persuade you that the English court should abandon Aerotel in favour of an any hardware-based test, and that the computer programme exclusion is engaged by ANNs. Nonetheless, say the appellants, the Court of Appeal misapplied Aerotel because, as per issue 4, they misidentified the invention of the claims, in particular by salami slicing the invention rather than considering it as a whole. And that's the appellant's case, paragraph 13 on page 33. And as per issue 3, that they wrongly applied a test concerning the technical contribution, and that's in the following paragraph 14 on page 34.
And do those issues not arise at all if we're going down a G119 stroke, well, any hardware plus convic approach?
Well, I'm not sure that they would, my Lord, because...
They might not arise in quite the same terms.
Yes, I mean, obviously the specific criticisms that are being made on these grounds is that Aerotel has been incorrectly applied.
Yes.
But they do nonetheless raise in themselves issues of how they contend that it should have been, the Aerotel test should have been applied, which may apply if you follow the convic approach. But they don't specifically lead on to, they won't specifically answer the question of what the outcome would be on convic.
No.
No, they probably don't entirely answer the question, because you'd have to go right through the convic
Correct.
test. But insofar as there was salami slicing, or insofar as there is a failure to get the technical question right, that might arise under both tests.
It may.
Yeah.
May.
And I'm just looking to see whether there is built into your opening broadside the proposition that if we accept the appellant's case on issues 1 and 2, we don't get to 3 and 4. I think that is what you're saying.
That's what the appellants are saying.
It's what the appellants are saying.
Well, yes, but I think I don't understand you to be challenging that.
Well, no, because, of course, if they're correct on the... Well, if they're correct on the question of whether or not the computer programme is engaged by the ANNs at all,
Well, that would be...
that's a very different, that's a very different analysis.
Indeed, issue 1 rather than
Correct.
2, yes.
Yeah. But we say that there's no reason to change Aerotel, and in any event, the Court of Appeal got it right. So if I can just pick up the Court of Appeal judgment, please, on page 152, at paragraph 28, and this is where Lord Justice Burse begins his section, the law and outline, and at paragraph 30, he recites, he makes reference to the 2 cases that are generally cited at this stage, and those being Aerotel and AT&T. And as he explains at paragraph 34 on the following page, in the right sort of case, In the right sort of cases, what we have referred to as the better computer cases, where the invention is said to improve the functioning of the computer system itself, these AT&T signposts can be quite helpful. However, in the present case, at paragraph 76, Lord Justice Burse explains that this is not, in fact, one of the better computer cases because it's not, in fact, concerned with improvements inside the running of the computer. And then, perhaps unsurprisingly, in light of that, at paragraph 82, he records that the AT&T signposts did not help. And that's no doubt why the appellant doesn't contend on this appeal that the Court of Appeal was wrong in its assessment of the AT&T signposts, or indeed why they haven't featured very much, if at all, in the written case, and not at all orally. And then going back to paragraph 31, on page 152, Lord Justice Burse reproduces the error-tell test, and over the page, at paragraphs 32 to 33, he explains the purpose of that test. And starting first at paragraph 33, Lord Justice explains that at the heart of the law is a consistent principle that an inventor must make a contribution to the art, that is to say that the invention must be new and not obvious, and that the contribution must be technical in nature, that is susceptible of industrial application, and not within one of the areas excluded by Article 52(2). Leaving aside for present purposes susceptible of industrial application, one can see clearly from paragraph 33 that Lord Justice Burse is using the phrase technical in nature to mean not within one of the areas excluded by Article 52(2). So what Lord Justice Burse is saying at 33 is that the contribution must be new and not obvious, or to put it another way, old and obvious aspects of the claim do not form part of the actual contribution, and that the contribution must be technical in nature in the sense that it must not consist solely of excluded subject matter.
Just pausing there, if for it to be a contribution, i.e. that is to say it must be new and not obvious, why is therefore contribution not the same thing as inventive step? Which is what he says in the previous paragraph. Because
there may be situations where your inventive step resides in aspects of the claim that don't necessarily form the same part of the claim that is being relied on for the contribution. But where you have a totality of the claim, you can nonetheless have there can be situations, they're hard to conceive of, but there are situations where the inventive concept is not the same as the contribution.
So you say what he means in 32 is that it may be an inventive step, but it's not a contribution.
Correct.
Okay.
In fact, a case in point may be, for example, the very clever bit of the ANN in this case. The Court of Appeal have decided that the ANN falls entirely within the scope of the excluded subject matter.
Yes.
Yet it is what's said to be the clever bit of the alleged invention.
Yes.
Now, it may be that in the end, once inventive step and the totality of the patentability of the claim has been looked at, it turns out that there's no claim at all. But that is an example of where the alleged inventive concept is not something that forms part of the contribution when the contribution is properly assessed.
Certainly, as I understood the submission made against you by the appellant, even if it does constitute excluded matter as such, it is not standing alone in the context of this particular invention. And so it is said that it does have a technical effect in any event, and it does make a contribution because it isn't an abstract program. It's a program which is harnessed into a system which has a real-world practical use, and so it is technical.
Understood, and I'll come on to explain that when I deal with the specific objections that are made, the specific criticisms that are made as to why I say that's not correct. But we absolutely accept in principle that one may have situations where you can have a patentable claim by virtue of the interaction of a non-technical and a technical feature.
Or even excluded subject matter and another component which is not excluded.
Absolutely, so I was using non-technical and technical in exactly that sense, but that's exactly what we had in mind. And one can see now and we say that rightly the appellants make no criticism, at least within the scope of issues 3 and 4, of the summary of the law that we see in paragraphs 31 to 34. Rather, they confine themselves to a criticism that the Court of Appeal wrongly applied Eretel. So if we can just pick Eretel up, which is at page 341. Oh, sorry, at page 358. On paragraph 39, where Lord Justice Jacob introduces what's now known as the four-step Eretel test, and he goes on to explain what these stages involve. But before he does that, he records at paragraph 41 the Comptroller's submission that the approach is structured and said to be workable across the whole field of the exclusions under section 1.2, not just the computer program exclusion. And that makes this a particularly helpful, structured approach. And picking it up at paragraph 42, Lord Justice Jacob explains that the claim must be properly construed so that the monopoly is properly understood before going on to determine whether or not it is properly excluded. And then at 43, that part is to identify the actual contribution. And as Lord Justice Jacob observes, this can be more problematical. What is meant at this stage, as he goes on to explain, is to ascertain as best one can what it is that the inventor has really added to the sum of human knowledge. Now, in some cases, it may be self-evident that aspects of the claim can be excluded because they may, for example, be stated in the specification itself to be entirely old and conventional. And at 44, he explains that in some cases it may be necessary to consider the alleged contribution because it simply may not be possible on the materials before the tribunal to determine the actual contribution, and it may be necessary to accept what the inventor says is his contribution. But as he goes on to explain, what the inventor says is not necessarily determinative, where the inventor alleges wrongly, for example, that he's invented the wheel, and so asserts that the wheel is part of his contribution. The tribunal isn't necessarily bound to accept such an assertion. As he says at 43, it's all an exercise in judgment. It
may be that certain aspects of the prior art are acknowledged in the patent itself.
Well,
indeed.
Indeed. And so it may be in some cases it may be possible, in others it may be harder. But the fallback position, if it can't be done, is that you accept as the contribution, the alleged contribution put forward by the applicant. The third step, as explained at 45, is to ask, is the actual contribution solely of excluded matter, or does the contribution thus identified or does the contribution consist solely of excluded subject matter? And then the fourth step is this cross-check to check whether or not the actual contribution is technical. And that may be necessary, but normally the expectation is that that will be dealt with at step 3, but nonetheless it's a necessary cross-check. And I'll come on to deal with how that fits into issue 3 in due course. And then I just observe that at paragraph 48, Jacob rejected a submission made by Mr. Thorley that it was a rewriting of the statutory test, explaining that it's a structured and more helpful way of reformulating the statutory test. And he also observed that despite his submission, Mr. Thorley was unable to pinpoint any specific way in which the test differed from the statutory test as determined by this court. And just pausing there, it's important to note that the way the Eretel is structured is that it requires the court to first assess the contribution and then, having done so, assess whether or not that contribution falls within excluded subject matter. Now, the criticism of that approach that was made yesterday is it was said that that renders the test subtractive and leaves room for features of the invention to be wrongly excluded from the contribution. Specifically, it was said non-technical features which interact with technical features are said to be liable to be removed. But of course, if an applicant asserts that a non-technical feature interacts with a technical feature, then it can be identified by the applicant as part of the actual or alleged contribution. The tribunal will have to use its judgment whether or not to accept it as part of the actual contribution.
Do we get that anywhere from Aerotel itself, or is that just your submission?
About the non-technical features?
About how you accommodate interaction?
No, that's my interpretation,
so, yeah.
It just simply refers to the contribution by reference to having taken out of that what one considers to be old or non-inventive. And if, my Lord, we can perhaps quickly look at the claims in issue on this application. And if we start first in the Court of Appeal judgment, page 147, at paragraph 3, Lord Justice Burse explained that the two key independent claims are Claim 1, a system for providing file recommendations, and Claim 4, a method for providing the same recommendations. And he says it's convenient to think about the claims as if they relate to music, but in fact the application is applicable to other media and the claims are not so limited. And the claims are appended to the judgment at page 164. And as can be seen, Claim 1 is directed to a system for providing semantically relevant file recommendations, and that claim system contains an ANN which has been trained in the manner described at integer A, a database stored in which is stored a multiplicity of reference data files described at integer B, a communications network as integer C, a user device connected to that communications network integer D, process intelligence as described at integer E, whereby a file vector is obtained for the target database is accessed, and the file vector is of the target data compared with the vectors of the reference files in the database to identify relevant files, and then sending over the communications network relevant reference files to the user device, wherein the user device is arranged to receive the relevant reference files and to output the content thereof. Now, written as they are, the claims can be a little impenetrable. Lord Justice Burse summarised them in a more accessible way from paragraphs 19 to 25 at pages 150 to 151, and we've sought to do a similar exercise at paragraphs 99 to 101 of our written case. But in essence, the end user presents an existing media file to the system, say the Beatles, Lucy and the Sky of Diamonds. The system's ANN determines the vector of the input file and compares it with the vectors of the other tracks held in its database and selects at least one track from that database on the basis of the proximity of the vector of the input file to the vectors of the tracks in the stored database and sends corresponding track or tracks over the network to the end user. So these could be, for example, Pink Floyd's Wish You Were Here or Mozart's Horn Concerto No. 4 in E flat. But whatever they are, they've been selected on the basis of the proximity of their vectors to the vector of Lucy and the Sky of Diamonds. So the system uses an ANN to identify particular existing digital files.
This is the trained ANN.
This is the trained ANN. And what it's doing is it's identifying existing files from an existing database. And the system transfers the chosen file or files to the user over an existing communications network. There's nothing new in the system at all, except for the vector-generating ANN. And so, with that little background to how to read the claims, I'd just like to go very quickly through the proceedings so far, and I'll take this very quickly indeed, but what happened is when the case came originally before the hearing officer, because the IPO had formed a provisional view that the claims are bad in their entirety for comprising excluded subject matter, both as a method of mathematical methods and a programme for a computer as such. And the hearing office assessment begins on page 206, and in the usual way, he addresses Aerotel construction from paragraphs 34 to 42. At paragraphs 35 and 36, he explains that the claim 1 is a system claim and claim 4 is a method claim, and goes on to explain that one's a product by process, but for the purposes of this assessment, it doesn't really seem to matter. He construes the claim at paragraph 42 on page 207, and from paragraph 43 at the bottom of page 207, he addresses Aerotel Text 2 and the identification of distribution. And he explains at 47 how he's already covered how the invention works, and key to all of this is how the ANN is trained. It provides a trained system that can recommend semantically similar files by reference to the extracted measurable properties. And at 48, therefore, it advantageously reflects the subjective emotional perception of similarity between files. And at 50, he records a key pillar of the appellant's arguments, namely that the ANN of the claim can be implemented in hardware or software. And at 51, he observes that the contribution does not ride in the natural programming language or the extraction of measurable properties from files per se. This is an example of where something can be taken out of alleged contribution simply by virtue of the fact it's acknowledged in the specification itself to be known. And at 52, the hearing officer records a statement of the contribution that was advanced by the appellant, which the hearing officer stated suffered from a lack of detail, in particular missing the key insight of how the ANN is trained. And that gave rise to the revised statement, which is set out at 53. At 54, we can see that the hearing officer considered this was a fair statement of the contribution, and that reference to accuracy reflects that the system is said to be better at identifying and recommending user files based on their semantic similarity. The hearing officer deals with steps 3 and 4 together from paragraph 55. And at 56, he records the applicants made 3 main arguments at different levels of generality as to why the invention was not excluded. The first is that the computer program exception is not even engaged because the claims contain an ANN. The second, on page 202 at 66, is that...
212.
Sorry, 212 is that... So I've slightly lost my place. Is that it is argued that the claims invention is to a wider technical system for providing file recommendations, and he goes on to consider that at 67 through to 70, and at 71, the third argument, which follows from the second, relates to the sending of an improved recommendation message over the network, and that was issue 3, and he rejects that in the discussion that follows at 72 and 73, and concludes at 74, therefore, that the 3 main arguments advanced by the applicant are not persuasive. And for completion, he goes on to consider the various computer signposts, and at 79, he stands back and looks at the invention as a whole and satisfies himself that the contribution falls slowly within the scope of the computer program exclusion. Now, very quickly indeed, if I can just briefly...
And can I just check?
Of course.
That I've correctly understood his paragraph 79.
Yeah.
The second sentence, I think, is the conclusion he derives from the first sentence rather than an additional conclusion, isn't it? Correct. Yeah.
And then, as we can see, what happened before Mr. Justice Sir Anthony Mann. So this is picking it up at page 176. We can see that he cites there that the statement of contribution that the appellant advanced before the hearing officer, and we can see there for completion that no issue was taken with that by the controller. At paragraph 61, he sets out his view that the exclusion is not invoked. And obviously that finding was sufficient to allow the appeal. But from 63, he goes on to consider the position of the event that he was wrong about that. Paragraph 66, he records that there was no dispute. At paragraph 68, he identifies the technical effect relied on by the appellant. So this is moving back to the sending of the file. And at 71, he records the appellant's reliance on Gemstar for moving of a file in that case being a relevant technical effect. And at 73, the moving of data as being a relevant technical effect. And at 76, he accepts these arguments that were put forward by the appellant and explains why the analysis of the hearing officer was wrong. And finally, now, if we look at the Court of Appeal, we can pick that up on page 161. And as explained there, there's no issue on construction. At 73, there's no dispute as to the contribution. At 74, who begins to undertake the error-10 analysis. And at 75, he observes that subject only to the step of sending the recommended file to the user, the whole of the remainder of the contribution consists of a program for a computer. And just pausing there, our reading of that paragraph is not that the judge was holding that the step of sending the recommended file was outside the scope of the exclusion. Rather, the focus is on that because that was the only aspect relied on by the appellant as taking the claim outside the scope of the exclusion. And we saw that was the same argument that was raised before Sir Anthony Mann and also the hearing officer. And then at 76, he says that, put simply, the programme here provides improved file recommendations. That's what it does. And we can see at 76, he says, this also illustrates why the present case is not concerned with improvements inside the running of a computer. It's not a better computer case. And at 77, the mere fact that the file is sent doesn't actually help. What distinguishes it from the standard file transmission is that the file represents a better recommendation, e.g. a song which the user was likely to enjoy. In other words, one comes back again to the correct characterisation of the function of the computer programme. In this case, 78, he addresses the approach of Sir Anthony Mann, and at 79 he concludes that the hearing officer's decision was correct, and picking it up in the middle of that paragraph, he refers to what makes the recommended file worth recommending are its semantic qualities. They are not technical and do not turn this into a system which produces a technical effect outside the excluded subject matter. And then he refers to Yahoo, and as I've mentioned already at 82, he says the signposts don't assist, which was consistent with his earlier finding that this is not a better computer case. So if we turn now to the various issues, and just as Mr. Chatsfield did, I will start with his issue 4. And before I do, can I please take this opportunity to correct something in our written case? As Mr. Chatsfield rightly pointed out yesterday, as drafted, the second sentence of paragraph 105 on page 113 is not correct. We apologise for that. What it should have stated is that those features do not per se form part of the actual contribution, as I will come on to.
Sorry, whereabouts?
Sorry, on page 113.
Yes,
Paragraph 105, and the second sentence is not correct. What we should have said is that those features do not per se form part of the actual contribution, as I'll come on to explain. I had thought that was common ground, but I now, given what was said yesterday, it's clear that that's not. And the thrust of the appellant's argument under this issue 4 is that the Court of Appeal misidentified the invention of the claims, in particular by salami slicing the invention rather than considering it as a whole. That is, the court addressed the claim piecemeal, ignoring some parts and rejecting others. We submit this is not a fair characterisation of the approach followed by the Court of Appeal. At paragraph 171 of their written case, the appellant states that the question is to properly identify the technical contribution of the invention of a whole and then to ask whether it is within or without the exclusions as per VICON. You don't understand this. The basis for this ground of appeal is that the correct approach is set out in Aerotel. Aerotel requires the courts, having construed the claim, to identify as best it can the actual contribution and then ask itself whether that actual contribution falls solely within excluded subject matter, followed by a final check that the actual alleged contribution is actually technical in nature. Returning to the judgment of the Court of Appeal, we can see at paragraph 73, that's page 161, that Aerotel Step 2 was not in fact in dispute, and Lord Justice Burse refers back to paragraph 37, which actually should be 38, where he sets out the statement of contribution as before the hearing officer at paragraph 53 of that decision. So the contribution that the Court of Appeal used in its assessment was simply the statement of the contribution advanced by the appellant. So we were at something of a loss as to exactly what the nature of the criticism of the judgment below was being advanced here. However, having heard Mr. Chaxfield yesterday, we think his argument is that the Court of Appeal must have somehow removed various bits of the contribution because there is no reference to the various bits of the hardware in the claim when he goes on to discuss the contribution at paragraph 75. And so, therefore, and because that hardware would have taken the claim outside the scope of the exclusion, it must have been the case that the judge has either overlooked it or incorrectly excluded it. Now, the argument appears to be that because the statement of contribution includes sending a file to a user device, and a user device is a physical thing, hardware, and so not caught by the exclusion, then the claim as a whole is outside the scope of the exclusion. This feels a little bit like the any hardware test. The invention in the present case is undoubtedly a computer-implemented invention. It necessarily includes a computer program, uploading files from user devices to communication networks, data processing of those files, and transferring files from a database to a network-connected user device by a communications network is all implemented by some sort of computer program. Now, obviously, the arrangement I have described plainly involves computers, the end-user device, the server holding the database. But as Lord Justice Burse observed at paragraph 32 of his judgment, it's not always the case that claims involving computers will fall outside the exclusion, even though obviously computers are about as technical as it can possibly be. But the user device per se is not part of the appellant's actual contribution at all. The database per se is not part of the appellant's actual contribution. The communication network per se is not part of the appellant's actual contribution. The arrangement of the user device, communications network and database per se is not part of the appellant's actual contribution. All of this is old. As Mr. Chaxfield acknowledged yesterday in response to a question from Lord Kitchen on page 36 of the transcript, he accepts that the database, user device and communications network are all entirely conventional. Furthermore, the arrangement of those components is also conventional. So the mere fact that those components of a system are all included in the statement of the contribution does not mean that the user device per se contributes to the contribution. It cannot, because it's known. We accept that the appellant's statement of contribution includes the provision of file recommendations to a user device over a communications network. But that doesn't mean that any of those individual components per se are part of the contribution. The appellant seeks to get around this by saying that the user device contributes to the contribution because it interacts with other aspects of the contribution. But the statement of contribution doesn't contain any reference to interactions. And it was never explained how it was that these devices did interact with each other in any way other than through conventional computer programming. We submit that the merely sending or receiving of existing files using standard file transfer techniques is not an interaction other than within the conventional programming of the system. Nothing happens to the file or the user device as a result. Put another way, the file is not a better or even different file as a result of being transmitted to the user device. and the user device is not a better or even different user device as a result of having received the file. One can see that the user device per se forms no part of the actual contribution, because any existing user device will do, provided it's connected to the communications network. The user device could be a smartphone, whether it's the latest Samsung device or last year's Apple. It could be a tablet computer. It could be a desktop. It really doesn't matter. And that's because it makes absolutely no difference to the invention or how the invention works. It simply forms no part of the actual contribution. Similarly, the communications network could be a local area network or a conventional wide area network. The device could connect by conventional Wi-Fi or physical connection with cables. None of this has anything to do with the invention. By simply asserting that the user device interacts with the file without explaining what that interaction involves and how it is precisely that the interaction is sufficient to take the step outside the scope of the computer program exclusion, is simply to point to the existence of a feature which consists of hardware as old as the hills and which has nothing to do with the operation of the invention, and claim that because this is included in your claim, you're outside the scope of the exclusion. In short, it's to apply any hardware test. There is no error of law on the part of the Court of Appeal. That leaves ground 3. By this ground, page 34, paragraph 14, the appellant alleges that the Court of Appeal wrongly applied a test concerning technical breach of the claim's invention and, as a result, wrongly applied the statutory test. This ground needs to be understood in the context of the manner in which the application has progressed. Obviously, what's happened in this case is that the hearing officer took the view that the entire claim fell within the scope of the exclusion, and it was the appellant who was trying to find arguments that it could deploy to take it outside of the scope of the exclusion. In other words, what the appellant was submitting is that when one asks oneself, as per Halliburton, what task is the computer actually performing, and one answers that question by sending improved recommendation methods, then they say that task is sufficient to take the claim outside the scope of the exclusion. But the problem is that the transmission process is achieved in a standard fashion and operates wholly within the conventional computer network. There's nothing about that that takes the system or the claim over and above the running of a program on a computer. Similarly, as Lord Justice Burst pointed out at paragraph 77, the mere fact that a file is actually sent doesn't help because the file transmission is no more than the standard file transmission of a file in a network. What distinguishes this case from the previous cases, Viacom, Gemstar, Protecting Kids, is there absolutely nothing in the provision of better recommendations where the sole basis for the betterness comes from the assertion that the recommended track will conform to the user's perceived perception of similarity. And the reason that it's not technical is because assertions as to the extent to which the end user will appreciate that the selected file is better is not enough to take the claim outside mere computer programming. I'll try and illustrate this with a quick example. Colonel Mustard's in the study on his desktop, which is physically connected to the house LAN. Mrs. Peacock is in the billiard room with her tablet connected to the house LAN by Wi-Fi. Professor Plum is in the ballroom with his smartphone, connected to the external 5G network, but his reception is weak and intermittent. All three of these characters choose to use the same invention, employing the same embodiment of the ANN and the same database. And they all choose to upload the same input file, the Beatles, Lucy and the Sky of Diamonds. Because the ANN and the database are identical and deterministic, the ANN will select the same tracks from the database of reference files, and each of Colonel Mustard, Mrs. Peacock and Professor Plum will be sent Pink Floyd's Wish You Were Here and Mozart's Horn Concerto. Colonel Mustard is delighted. He'd never heard of Pink Floyd and loves Wish You Were Here. He'd also long loved the Horn Concerto and was delighted to hear it again. Mrs. Peacock is horrified. She can't stand Pink Floyd and hates the Horn Concerto. And Professor Plum's reception is so weak that by the time the two tracks have downloaded, he's forgotten he'd even asked and is now happily reading a book. There's no question that all three characters have used the same system. In each case, the response or impact on the end user is different, positive for Colonel Mustard, negative for Mrs. Peacock, and indifference on the part of Professor Plum.
I can't see that whether the end user likes the song recommended is any part of the invention anyway.
Precisely.
Surely what matters is that it produces a more semantically similar track, and whether people do or don't like a track identified in that way is neither here nor there.
Absolutely, but the fact that the track is more semantically similar is in no way is not a technical effect, in the sense that it doesn't do anything over and above the existing programming that's already taking place within the system.
It's a semantic effect. You obtain a semantic similarity as opposed to a technical effect. And because the whole thing is based upon initially training it in semantics, and you achieve a semantic effect.
Indeed, but the semantic effect is not technical at all.
That's right.
And,
well,
but
that's one way of articulating
Indeed, but it's also non-technical because it's not actually doing anything other than taking advantage of the existing computer programming. It's not, for example, making the track, making it smaller so it takes up less size or can be transmitted faster or more quickly, or take up less space. It hasn't been cleaned to remove errant coughing from the audience on recording of a live track. Nothing like that is happening here. No. All that's happening is existing tracks are the same. Existing files are moved using existing mechanisms in their existing file formats and received in exactly the same file format.
What is being suggested is that making a recommendation achieves a technical effect. But those technical effects depend on subjective choices, which are entirely semantic. And I'm not certain at present as how that amounts to a technical effect. It results in a semantic recommendation.
Correct. That is exactly what we say. We say that it is not technical, and merely using technical means such as the ANN in circumstances where that is in itself a computer program is simply selecting semantic similarity using excluded subject matter. And it is not technical for that.
Why isn't selecting semantic similarity more accurately or more closely, or however you want to describe it, an achievement of this invention, which isn't simply a program, not simply a computer program?
Indeed, it may well be, but for the purposes of this issue 3, the ANN has been the computer program exclusion applies to the ANN, and so all of the clever selection by the ANN using the vectors and the similarities of the vectors and the semantic similarities is all part of that computer program function that's been carried out by the ANN.
Well, I can see that, but if that's right, how does the better computer concept fit within Aerotel?
Because within Aerotel, when one comes to assess the actual contribution, you can take into account the effects that the running of your computer program is having on your computer. It may make it work more efficiently or use less power. But
in this case, the training is said to enable the ANN, which is for this purpose to be assumed to be your computer, at least if it's a hardware ANN, to get to an approximation of a semantic recommendation by using purely objective factors quicker, cheaper, and more efficiently. So why isn't it a better ANN?
Well,
by virtue of the special training which it's had, which everybody seems to agree is the clever bit.
Well, and the reason it's not a better computer is because simply performing the function that the program is intended to perform, even if that had not been done before, is not a better computer, and it's not an effect that's being actually experienced in the computer.
If I buy a computer which does A, B, C, and E for me, and somebody comes along with a program that enables me to do A, B, C, D, and E for me, why isn't it a better computer?
It's a better program. It's not a better computer. Exactly. The trained ANN is a better trained ANN. It's got better weights and biases. It's more efficient and it's more quickly because of the computer programming.
Yes.
But that doesn't mean that the computer itself is any better. It's simply applying a better computer program.
Really depends on the outcome of the earlier question.
Well, indeed it may, and I think that probably I can't. I mean, I think that's probably the right place to leave it because I'm conscious that I'm running out of time, and I do, before I sit down, want to take you very quickly to the examination report of the EPO to explain how the convict approach would apply to the claim that we've just been, to the claims of this patent that we've been looking at.
You rely on the Yahoo case, presumably?
We do rely on the Yahoo case.
For what it's worth.
What it's worth, and in fact I'll show you because that's also relied on by the EPO.
Oh, is it?
Yeah, but we do rely on the Yahoo case.
And that's referred to at paragraph 69 of the Court of Appeal judgment.
Indeed, yeah. And so, my Lord, hopefully you received a clip of selected documents relating to the examination of the co-pending EP patent. And I apologise for its length. This is obviously not a complete download of the examination file. What we've tried to include is simply the letters from the appellant's representative and the examination reports that came back. Now, the first examination report, which is the one I'm interested in, begins at page 44, and this relates to the claims in these proceedings. And if I can pick it up on page 45, at paragraph 4, where it introduces independent claim 1, and as well as the corresponding independent claim 4, it says it's directed to providing semantically relevant file recommendations. The applicant specifies in its L1, that's the letter, point 3.2, that when a user enjoys an audio track, such as a piece of music, they can be provided with a similar track in a semantic sense upon the request of the user. And then it summarises the way that the invention works. And at the first paragraph 5, it says that claims 1 and 4 refer to a computer architecture using database among other components, which is considered technical, but which only relate to the technical implementation for recommending files to a user. It says, next, immediately beneath that, indeed, file recommendation, for example, a song, which is the purpose of the invention as disclosed in claims 1 and 4, to a user does not qualify as a technical purpose. And that's the reference there to Yahoo, TO 306, 10, paragraph 5.2.
So that recommendation of itself does not render it technical.
Correct. Correct. And over the page, top of 46, moreover, applying ANN and artificial intelligence techniques to provide file recommendations are based on computational models and algorithms, which are per se of an abstract mathematical nature, irrespective of whether they can be trained based on training data, thus lacking technical character. So here you can see that the ANN features are being identified as non-technical features. I'll be very quick. Paragraph 6.
You're running out of your extended time.
Oh, so I'll be very, very quick indeed then. In that case, at paragraph 6...
Well, at least identify the relevant paragraphs for us.
So the relevant paragraphs are paragraph 6, which says it's a mixture of both technical and non-technical features. And then at paragraph 8.1, you can see what's happened. The technical features are underlined. The non-technical features are left ununderlined. And at 8.3...
So this is applying convict.
So this is applying convict. And you can see at 8.3... just above that, all non-technical steps do not have any technical effect and do not solve any technical problem. Since they do not bring any technical contribution to the subject matter of Claim 1, they cannot support the presence of the inventive step. 8.3, all of the technical features refer to an arrangement which are considered notorious to the person skilled in the art in the field of a computer system, which are disclosed in any prior art in said field. And then at 8.5, the objective technical problem derivable from these features resides in the implementation of these non-technical steps. So the claim fails the convict test because when you remove the excluded subject matter, you're left with something that is new and not inventive.
The revised convict requires this analysis to go on at 8.1.
Exactly.
And I have not seen as yet that revised analysis being carried out in relation to the claims in this case. And I've said this before, but I say it again. No doubt it's going to be told I'm wrong, but anyway.
Well, we must give Mr. Jackson
That's what
is attenuated time.
Don't worry.
So just before you do, the back of this little bundle from
Yes.
page 68.
Yes.
This simply contains a summary of the relevant documents.
What you see at page 68 is a second examination report that was produced in response to further arguments and further amended claims.
Right.
And it essentially fails for the same reasons. So it's therefore completed, but the examination report that deals with the claims in issue in this particular case is the one I've just taken.
That's very helpful. Thank you.
Thank you.
I'm sorry.
My Lord. My Lord, Lord Stevens, I am going to say you're wrong, but hopefully in politer terms. I will remind my Lord, yes, I know. You might say it's a bit late said it, but anyway, forgive me for that. So, my Lord, I'm going to start with Convic and Pozzoli. And the way my learned friend presents this as this choice between any hardware plus Convic or any hardware Pozzoli is simply the wrong question. He asked the wrong questions and has led to enormous confusion as a result. And that's because, as my Lord Legate pointed out correctly, he had skipped over the really important intermediate point, and I will come on to explain that why. If we start with the statute asks, 1, is there an invention? And then 2, does that invention involve, inter alia, an inventive step? Those are independent, separate criteria, as is very clear from the EPO cases. Now, in the EPO, this is approached as a 3-stage test. There are the 2 hurdles, but there is the intermediate step, which is really important. I addressed this yesterday, but to re-emphasise it, if I can take my notes to G119 at paragraph 39, which is the bundle at 1217, please.
12.
1217.
Thank you.
1217. And you see, the 2-hurdle approach for computer-implemented inventions actually entails 3 steps. Establishing whether a feature contributes to the technical character of the invention constitutes an intermediate step between 1, what's any hardware, and 2, asking whether the invention, based on the inventor's step, vis-à-vis the closest prior art. So in other words, inventor's step. This additional intermediate step serves as a filter for features contributing to a technical solution or a technical problem in view of the closest prior art. Only those distinguishing features can contribute to inventive step. So it's critical, as this makes clear, it's only the features of the claim which are outside of the exclusions as such which can be taken into account for inventive step. And it would be wrong to take into account features which are properly excluded when you're considering inventive step. And we completely accept and embrace that. We highlighted this in paragraph 67 of our our written case. 67 on page 47, where we point out that any hardware approach does involve a bit of a shorthand or shortcut. The logic is that any invention which involves a piece of hardware will necessarily contain at least one technical feature, so is not excluded. But as in large board has reiterated, the invention of the claim must be identified as a whole, not piecemeal. And then we say there is, as 39 points out, in fact, an intermediate stage before proceeding to consider inventive step, which is to identify all of the features which contribute, against which question inventive step can be answered. And that was then picked up by us in our written case at 136, where we talk about the Pozzoli analysis. And we start off with a reference to Octavius and not Novartis. We say, in particular in the second sentence, all that is required for a mixed claim is a term used in the EPO for a claim with features that are technical and features which are not. All that's required for a mixed claim is the claim is properly construed to identify those features which contribute technically to the invention as a whole and to exclude any features which do not contribute. That should result in identifying the unit invention in the Article 52 sense. In other words, that which is not excluded it must be done following G119, having regard to the case as the claim as a whole. But then once that's been done, the question of inventive step can be analysed in the normal way. So the test is not any hardware plus convic. The statutory test, and paragraph 39 of G119 doesn't mention convic or problem solution at all. The statutory test is there an invention in the Article 52 sense? If you've got a bit of hardware, you know you have an invention and you go past that test. But you then, in the intermediate step, have to identify that invention properly, excluding all properly excluded matter. And then you can ask whether that invention has inventive step. But necessarily when you do that, you are not risking assessing inventive step by reference to things which fall within excluded subject matter as such. That's what the whole of G119 is about. It's about properly identifying the features which contribute, because those are the features which together form the invention outside of the exclusions. And once you've done that, you've got an invention. The statute then says you ask whether that invention is novel, has inventive step, and is capable of industrial application. It really is as simple as that. There's all this confusion going on. But all we're submitting to this court, and all the EPO does, is apply the statute according to the structure within that statute. So the right question is, if you've got any hardware, you know you've got an invention, then you have to identify the invention as a whole properly, and then you ask inventive step. So it's any hardware, ID the invention, and inventive step. 1, 2, 3. Now, within the EPO, it is right that inventive step is often addressed by convic, problem solution, but as we've seen, that's not obligatory. My Lord saw from my learned friend's written case, we made the same point in footnote 31 of our written case too, referring to Actavis Novatus, which is page 26 of Actavis Novatus, which is 338 of the bundle.
338.
338, my Lord, sorry. Now, it's right that convic introduces a particular device to assure that in the context of the problem-solution approach, that one doesn't inadvertently start looking at features which are properly to be excluded when considering inventive step. But that's just a belt and braces. It's not necessary because all of the excluded features have been excluded before you get there. Within this jurisdiction, inventive step is often, but again, is not obligatory, assessed using Pozzoli. Now, in my case, it would be wrong if I was to advance a case before your lordships, where I said inventive step is to be assessed by reference to features which should be excluded. But we do not do that, and I've shown you the particular paragraphs in my written case where we were very careful to identify this intermediate step and identify how that fits in with Pozzoli. So we do exactly what G119 says as a matter of law is the right approach, and that you can see in the structure of the statute. Now, my learned friend says, but we're thrown on the horns of a crisis as to how one actually does that to identify the features, but it isn't difficult. I spent quite some time yesterday addressing your lordships on exactly what VICOM says and what G119 said as to how one identifies the technical features of the claim that matter. And we set out at length in the supposedly irrelevant historical bits of our written case. It tells you exactly how to do it. Now, obviously, on the facts of any case, judges have to get paid to make judicial decisions. But the case law is easy in the sense of it's set out clearly in VICOM, which emphasises one has to identify the claimed invention at the level at which it's claimed, not getting distracted by questions which are questions of mere implementation. So if for a computer implemented invention you claim the method that is performed by the computer, the method of canning a soup that the computer controls or flying the aeroplane that the computer controls. That is a claim that you can have. It's technical and is not a computer program. What you can't claim are the computer instructions to the CPU itself. And that's absolutely clear and runs through all those paragraphs at the end of VICOM, from 12 right through to 16. And what G119, as I said, is all about is giving a slightly more structured approach once one has identified the invention properly to ensure that you do include all features which properly should be included, and to make sure that you do exclude all features properly to be excluded. And one does that by identifying the features which contribute to the invention. And we saw that G119 at least gives guidance on how one actually looks for interactions and technical features, and those are paragraphs 85, 86, and 88 of G119, which I showed, my lords. And the thing that it makes very clear, well, there's two things that those paragraphs make very clear. Firstly, interactions are going to occur in all sorts of ways. Measurement of analysis or analysis of an external thing. VICOM was the external analysis of a digital media file. My claim involves the external analysis of a digital media file. It can arise out of outputs from the back of the computer system. That doesn't arise in VICOM, for example, but it does arise in cases such as GemStar that I referred my lords to. There's two IBM cases I referred to in my case. Protecting kids was another external interaction by outputting a message. And in my case, there's a message that's output at the back end, which is a second interaction with reality. You can also interact in other ways. You can have things that are just purely internal to a machine. But as you recall, I think it was 88 of G119, the board said that it's not necessary to have an external interaction, but if you do have one, you're highly likely to have an invention. And I also showed my lords Halliburton in this jurisdiction, where His Honour Judge Burst QC, as he then was, said the same. And he said, if you have an external interaction, you are likely to be outside the computer program exclusion. And the reason is, if you then look at it from a VICOM way, if you've got an external interaction, the correct way of characterising your claim is likely to be not the program that's running, but to say what it is the computer's doing. It's a better method of analysing things, it's a better method of canning soup, it's a better method of flying an aeroplane. And that's why if you have an external interaction, you will normally have a claimable claim. It may not be patentable, but you'll have subject matter. The time when it fails is normally, probably entirely, where that which is done by the computer, the external thing, is itself within another exclusion. So in Merrill Lynch, a computer was used to create trades. And there's another one of the cases, I forget which one, where it was used to create company formation documents. In both those cases, the claim failed, but that's because, it's not because, and Lord Justice Burst makes it clear in Halliburton, it doesn't fail because it's a program for a computer. Because it's not, it's got an external effect. It fails because the external effect is within a business method. So it fails for a different reason. And he points out that's really important, and it is really important to understand that. So going back to where I started from, the simple point out of all of that's been discussed before your lords is to identify the statutory questions. Is there an invention, and if so, exactly what that invention is? By invention, I mean that which is claimed less any features which are properly excluded. And then you just ask, does that invention involve inventor's step? Now, that can be addressed by Pozzoli. And we didn't think, as we set out in 136 of our case, that you needed to write out the rider for Pozzoli, because that's just inherent in properly applying G119 and VICOM. But if you want to do the rider to double check so people make sure really to do it and they don't make a mistake, then the rider tells you to do that. Now, my learned friend says, oh, it's terribly confusing, this rider, it's got no guidance. It's drawn from the language of 31 sub 1 and 32 of G119 itself. So our case is not that one has to do Pozzoli, one has to do Convic, one has to do anything in particular when it comes to inventive step. One just has to apply the correct approach to the statute to identify the invention itself, and then you assess whether it's obvious. Now, you may do it through Pozzoli, you may do it through Convic, but they are both optional. You can do it through any other way that you think is appropriate as an assessment for inventive step. So the choice before my lords is definitely not any hardware plus Pozzoli versus any hardware plus Convic. The choice is any hardware plus identify the invention properly in G119 or in our rider to Pozzoli, and then is it inventive, and you can do whatever you want with inventive step, because you will never be assessing inventive step by reference to excluded subject matter as long as you properly identify the unit invention itself. And that, of course, is entirely consistent with that passage from Octavius and Icos, which, contrary to my learned friend, didn't say Pozzoli is obligatory. Quite to the contrary, it said all these options are optional, and there are plenty of cases where English courts have used problem solution. I can't remember if there's any in the bundles, and quite often it's done as a cross-check. They'll look at Pozzoli, and then there'll be arguments advanced about other approaches, and the courts will say, well, even if I take problem solution, get the same answer. There's no problem with infringement either. And my lords will now see why. Once the claim's been properly identified, in fact, it's even easier than that, actually. For infringement, one just construes the claim and asks whether it's infringed. My learned friend says, well, what if something's excluded? But the answer to that is exactly as my Lord Justice Kitchen said. Well, it serves the limitation on the claim. So you don't infringe if you're outside of that exclusion, because you've chosen to write in a limitation. It may not be a technically relevant limitation, but if you choose to limit your claim, then that's what you pay for. And the English courts are used to doing that. I mentioned yesterday that the English courts are familiar with ignoring features for the purpose of assessing inventive step, and I gave the examples of arbitrary features. There's a classic thing called a 5 3/4 inch plate, which from my Lord Briggs nods. But yeah, the example is this. If you claim a plate that's 5 3/4 inches in diameter, and it hasn't been done before, it may be said it's not obvious. Why do you do that? It doesn't do anything useful. It's just a number. So that feature is ignored for the purpose of inventive step. Nonetheless, you don't infringe that claim with an 8-inch plate. It's ignored for one purpose and not for another. And the other one is what's known as a lines in the path type argument. And that arises where you have a claim that has a feature which, for the purpose of inventive step, you say, well, the skilled person would think that wouldn't work or it would be deleterious, so they wouldn't do it. It's not obvious. But where the patent doesn't actually show or explain that it would work or is useful. In those circumstances, the patent adds nothing to the knowledge of the skilled person, and the court will ignore, for the purpose of assessing inventive step, that feature. For infringement, if you don't have a feature, you still don't infringe. We're suggesting nothing different here at all.
And is there any reason why the discretion can't be exercised in a similar way to how it is at the moment?
The discretion on obviousness, my lord.
No.
The 17.55B or whatever, the discretion of the...
Whether to conduct a search.
Whether to conduct a search.
Oh, crikey. Well, on that, my lord, I have two basic points. Firstly, substantive patent law cannot be driven by questions of cost effectiveness of searching by patent examiners. If my client is entitled to a patent, or anybody is entitled to a patent, and this makes a difference, then they're entitled to that patent. They can't be denied it because it makes searching more efficient. Secondly, it's not clear to us, so I think I said 2, I've got more. Secondly, it's not clear to us why it would make it more difficult. If there's a claim, and people do make claims to things that are purely excluded subject matter, if somebody claims, and you've seen that in some of the cases we've been looking at, indeed, if the patent examiner looks at something and says, well, that's all in the excluded subject matter, it's going to be obvious, I don't see at all why they can't then rely upon 17C, whatever, to say, oh, I'm not going to do a search. We don't see it, thirdly, we don't see any indication that EPO consider it problematic. And fourthly, the interveners, who are a lot more familiar with subject matter than I am, but the interveners say the Patent Office is using this procedure too much anyway. And for your reference, that's the intervener's case at 10.20. It's page 141 of the bundle. So that's what I was going to say about that, subject to any questions from my lords. On, sorry, let me just, just a few sort of tail end points. My learned friend said under Aerotel 3 that the applicant can just pick and choose their contributions. There's no harm in the fact that Aerotel strips out, sorry, Aerotel 2, they can pick and choose what they say as a contribution. So there's no harm that things are stripped out at an earlier stage. But that's wrong. If one looks at Aerotel itself, paragraph 44, which is bundle 3, sorry, page 359 of the bundle. See, sorry, it's my lord, what one says there is Mr. Burst added the words alleged contributions formulation second stage. While that to an application stage where the officer must generally accept what the inventor says, it cannot actually be conclusive, however. If the inventor claims a computer when programmed with his new program, it will not accept him if he alleges wrongly that he has invented the computer program, even if he specifies all the detailed elements in his claim. So it's not that, as my learned friend sought to suggest, that if you say I want it in, it has to go in. The Patent Office may say, I disagree. And you see that throughout this case on the facts. Throughout this case, I have been advancing the contribution being that at 53. And in all this, not all hearings, in the hearing officer and the Court of Appeal, they keep stripping out all the bits I say that matter. They don't ask me about interactions, they just strip them all out. That's a concrete example of why my learned friend is wrong.
So if I just can return to the issue, you have the claim for as a page 165. As I understand it, 2A requires, and indeed G119 requires, there to be consideration of removing features of the claim which cannot contribute technically to the overall invention because they are excluded matters.
Yes.
Now, where have you considered claim 4 to exclude those matters?
My lord, if I can, I actually addressed this yesterday by reference to the contribution rather than this document.
Well,
let's do it by this. So, what one has to do is identify what the nature of the invention is as a whole, as per Viacom, and then ask which features do and do not contribute. And you'll have seen the nature of the invention as a whole is it's a better method for making media file recommendations with certain features, and that's what paragraph 53 of the hearing officer's decision is about. So that is the overall invention. Now, when you then look at this invention contains within it a database. You see that at, I have to, pick them out as I go through. You'll see that there's a database at the lower paragraph B.
Yeah.
That's hardware. That contains, obviously, data relating to the previously analysed tracks. There is, in C, one receives target data as an input. So that is an external data file, the music track, just like the external data file in Viacom. And that is then run through the ANN to produce the physical properties ANN to produce a vector. As a result from that, the vector is compared with the data in the database to identify the similar track. Then in E, you see the communications network, which is a hardware thing, and you see that you're sending over that hardware a message, the recommendation message and file. That is a concrete item, as in those other cases I referred to. There's also the user device as well. Now you have the ANN in this case.
But just so as I understand it, you don't strip out anything from paragraph 53.
I would say in this case not, because, and I'll tell you why. It's
Okay,
because,
so as soon as you get over the hardware hurdle, that's it.
Can I take that in a few steps? So
Yes.
in this case, let's take particularly the input file and the output file. And they interact with the ANN of the invention, even if we assume that we've got a program and a computer there. They interact with that because the ANN performs an analysis, in fact it's a new analysis, on the data file. So there is an interaction there, a technical interaction, exactly of the type considered in G119 indeed. And then the output file, the recommendation message, is a different and new recommendation message compared to the prior art because of its content. Save in cases of extreme random chance, that message is new. And it will be different to that which the prior art would produce, and it is a physical entity, to use the language in VICOM 4. So it interacts because it's a different message. If you take a really absurd example, if we had the claim, but then at the last stage, the recommended file was recommended just using a random number generator, then there would not be an interaction between the ANN and the message. But in most cases, patent attorneys will and inventors design these things so that they do all interact all throughout. And this is why, and so it is often the case, my Lord Stevens, I don't shy away from this, it is often the case that inventions will pass through the exclusions, but that's because of two features which follow from the statute itself. And it might only be one feature. You don't construe what the invention is by reference to the prior art. In fact, in one of it might even be G119, it says, if you have a mathematical method and you work out the and it claims a mathematical method using a pen and paper, that's not in the exclusions because a pen and paper is technical. There, you won't get through obviousness, obviously. But any technical feature will get you through. So it is absolutely true to say, my Lord, that any hardware test is very, very low. But that is why the intervening step is really, really important. Because that means, because it's at that step that you strip out and you ensure that everything that's excluded is stripped out.
Well, give me an example of something excluded in this application.
Sorry, so a feature which is excluded.
Yeah, that's right. We've got the claims at page 165, claim 4. What's excluded?
I'm not sure that anything's excluded. The training step makes me pause because the training step is just a description of the thing that this claim claims the finished article, and the training step just describes it and what's known as a product by process claim. But the rest of it, they all interact because the message, the input file is analysed by the ANN. The ANN therefore interacts with the database and investigates the database. That identifies a new target file, and then you get a different message being sent out to the user. And my Lord, sir, I'm aware of...
Well, so long as you devise it in such a way that everything interacts with each other, then the exclusion of a program for a computer is meaningless.
It's not meaningless, my Lord. There are cases where if you just claim a computer program, you've seen this, in fact, you've seen there's cases where you just claim something like a naked computer program where it can be excluded. And we've seen some examples of that in the papers, but I don't shy away from the fact they're rare, and that's exactly the point that Lord Justice Burse does make in Halliburton. It is true, but they are not meaningless because you have to ensure that you properly identify an invention in the second stage. Any hardware is a very, very low hurdle, but the second stage, the intervening step, is really important. And once you've done that, you have identified everything that's not excluded.
But you have thereby included everything which, if it stood alone, would be excluded, providing there's an interaction with something
That's
else.
what the law is in G119.
No, I understand.
Yeah, indeed. And my learned friend, throughout my learned friend Ms. Edward Stewart's submission, she was just taking things out of the claim. As I said right yesterday, just keep an eye on the thing. She was just stripping things out all the time. No discussions about interactions and proper analysis. It just takes them all out. It exactly makes my point about point one, question one. Now, my learned friend has said it's surprising there are no examples. Finding examples is very difficult where you've got different results. I don't even know how to do that search, but he also didn't point my laws to section 73(2) of the Act, which says that if somebody attains identical GB and European patents, then the GB patent has to be revoked by the Comptroller. So you aren't going to want to do that to start. You're not going to want to find claims that are identical. Also, in 8.4 of their intervention, the interveners explicitly say that the different approach to the Act makes substantive differences. In terms of, I've got to be extremely quick on naive ANNs and ANNs themselves. My learned friend made some submissions about the nature of ANNs, which we say are simply wrong. He submitted that the ANN of the invention here, which had a certain number of 512 and 1,024 nodes, was a standard form ANN or something. That's absolutely wrong. That's absolutely wrong. There's no basis for that in the patent or in the evidence. It is an example given in the patent. But there is no statement anywhere that's a standard form design. There is no statement anywhere from Professor Pardo that these standard form ANNs exist. That is simply not supported by the evidence. And indeed, it was somewhat contradicted by my learned friend himself when he said one of the key skill sets of a computer scientist is to understand how to select the appropriate numbers of nodes and layers.
With respect, I don't think it's ever been part of your case that a naive ANN, or how to make a naive ANN, is part of your invention.
No, it's not. But this is a point about programmability. He says you can get off-the-shelf things with 10 layers.
Off-the-shelf is,
Yeah. But
rhetorical flourish, I can call it.
No, I'm not saying we invented the ANN at all.
Yes.
No, my lord. But what he seeks to say is he seeks to draw a comparison. He seeks to say that you can conceptually divide an ANN into its topological structural components and the nature of those components themselves. And he took, my lords, to figure 6 in the patent, where each of the components had a value associated with it. That's not a program, that's just describing what the component is. And in a hardware ANN, that would be its resistance. In an emulation, it's just the characteristic of that node or that link in the chain. And we say that's very, very different from what a computer program is. As I said yesterday, looking at the characteristics of the individual links and nodes and weights and biases, and trying to conceptualize this as a structure and then an overlying program, is wrong, because those numbers tell the designer how to design the ANN. And an instruction in our skeleton at 148, and my lords, in 148 we analyse, to 150, we analyse the nature of instruction really quite carefully in this field. And they are instructions used in the sense of commands instructing parts of the system to operate in particular ways. And that is not, and they're also coded commands in a computer. That is not apt to cover or include descriptions of just characteristics of the elements of the ANN. And you'll recall my learning friend sought to equate those to a computer program by saying, well, they're just numbers. But in a computer, if you get the number 00101, that doesn't mean the number binary of 17 or whatever it is. It means, when you flash it to the CPU, take data from one place, divide it by another number and store it in a third place. Or it might mean print data to the external printer. They are coded commands, and you see that throughout 148 to 150. They're coded commands about the operation of a computer. Whereas what he's talking about is things that describe the nature of the ANN itself. And it's also, sorry, if I can have just one more minute, it's also no distinction over the examples we gave as to things also covered by the Court of Appeal's construction. If you consider the toaster, which he started with, the toaster, as you twist the dial, you're giving it a program. You're setting it up to operate in a particular way. You're giving it instructions to operate in a particular way. Now, my learned friend said, but that's given by the human. Well, given his case is that involvement of human is irrelevant because an ANN is not written by a human. That's slightly difficult for him. But actually it doesn't help him anyway. It just means that these are a fortiori. A toaster is more programmable. And if you want an example which is like a fixed ANN, you look at the circuit in a smoke detector. That's all been optimized during the design process, and then you're just printing out the frozen optimized article. You can think about the oven. Can I do 2 points?
I think you've had at least your extra allowance accounted by the fact that Ms. Edwards finished slightly late.
My Lord, yes. Could I say one sentence without too many hyphens, which is the last point they mention is about complexity. That too is no distinction. An ANN can be a very simple thing, and you see that in the Court of Appeal at 7, whereas our examples can be terribly complicated. So the filter circuits within one's mobile phone is a really complicated bit of kit, but it's still just a bunch of capacitors and resistors in a network. Those are no distinction against the ANNs that he wrote.
Now, may I just ask a practical question before my Lord invites us to rise? Counsel for the respondent, I think, referred to a transcript.
Yes.
Do I understand there's a transcript of the oral submissions?
For today? Oh, sorry, for the hearing?
Yes.
Yes, and I apologise. I had understood that...
We may not have received it.
Oh, you have, have you?
We've got one, yes.
I see. I hadn't personally
I apologise. We should have flagged that.
Thank you.
Thank you. And the court is most grateful to counsel, all counsel, and also those who have no doubt assisted behind the scenes in preparing the oral and written submissions in this case, and indeed to whoever did the work for the intervener. It will come as no surprise to learn that we intend to take time to consider our judgment.